My own mother screamed in court. Not a raised voice, not controlled outrage. She screamed. She stood up in Milwaukee County Courthouse, finger shaking in my direction, and told the judge I was mentally incompetent. She said I was unstable. She said I was manipulative. She said I had isolated my grandmother. She said I should never be allowed to control her estate. There's something surreal about hearing your mother try to dismantle your credibility in a room where credibility is currency. I didn't say a word. I was wearing my grandmother's pearl earrings. They were small, understated, the kind she wore to church and to jury duty and to every single parent-teacher conference she ever attended for me when my mother didn't show up. They felt heavier than usual that day. Across the aisle, her attorney, Bradley Fenwick, shifted his weight like he had stepped into a situation bigger than the one he had prepared for. The judge wasn't looking at me. She was staring at him. And then she asked the question that detonated the room. "Counsel, do you truly have no idea who this woman is?" He blinked, because he didn't. My mother didn't either, and that was their first mistake. Let me pause here, because if I tell this chronologically, childhood trauma, abandonment, reconciliation attempts, quiet caregiving, death, probate, you'll miss the architecture of what happened in that courtroom. You'll think this was emotional. It wasn't. It was procedural, and that's what made it lethal. So instead, let me tell you what the judge knew that they didn't. My name is Nancy Berglund. I am 33 years old, and I am a certified fraud examiner based in Milwaukee, Wisconsin. For 7 years, I have specialized in elder financial exploitation. That means I don't just work in finance, I dismantle fraud ecosystems. I investigate forged powers of attorney, manipulated wills, coerced beneficiary changes, caregiver embezzlement, undue influence patterns in probate disputes. I trace bank withdrawals down to timestamps. I reconstruct signature irregularities. I analyze medical capacity records alongside transactional behavior. If someone siphons money from an elderly woman using emotional leverage and legal loopholes, I am the person prosecutors call. I have testified in 38 cases, 31 convictions. 11 of those testimonies took place in that exact courtroom, in front of that exact judge. Once, during sentencing in a particularly egregious exploitation case, she said on record that I was one of the most credible financial crime witnesses she had seen in 20 years on the bench. She didn't hand out praise, she handed out consequences. My mother had not spoken to me in 19 years. So when she stood up and screamed that I was mentally incompetent, she had no idea she was accusing the wrong woman. But that wasn't even the worst part. The worst part? She wasn't just trying to humiliate me, she was trying to steal from the dead. And she almost got away with it. Let me take you back 8 months. My grandmother, Dorothy Berglund, died peacefully in her sleep, congestive heart failure. 81 years old. I was holding her hand when it happened. There's a stillness that follows the last breath of someone who raised you. It's not dramatic, it's not cinematic, it's administrative. Because after grief comes paperwork, and I handled all of it. The funeral arrangements, the medical bills, the hospice reconciliation statements, the utilities, the bank notifications. She left me everything. Not millions. Her modest house on 54th Street, her savings, just under $240,000, a small life insurance policy. But it was hers, and more importantly, it was clean. Her will had been updated 2 years prior, witnessed properly, notarized, executed in compliance with Wisconsin probate statutes. I was present when she signed it, not hovering, not influencing, sitting across from her at the dining room table while she corrected the attorney's typo in the middle initial of my name. Her cognition was sharp enough to embarrass medical interns, which is why the letter I received 3 weeks after the funeral didn't just shock me, it insulted me. It arrived in a cream envelope. Return address, Bradley Fenwick, attorney at law. The tone was confident, polished, slightly patronizing. My mother was contesting the will. She alleged diminished capacity. She alleged undue influence. She alleged isolation. Then came the line that made my stomach drop. She has a documented history of mental instability. That sentence wasn't about inheritance. It was a character assassination attempt. If that allegation gained traction, even briefly, it wouldn't just threaten probate. It would threaten my license, my certifications, my expert witness credibility. In my profession, perception contamination is professional death. So I didn't cry. I audited. When someone accuses a fraud examiner of fraud, you do not defend emotionally. You reconstruct timelines. The first thing I did was pull every medical record from the last 5 years of my grandmother's life. Cognitive evaluations, primary care notes, cardiology consults, medication logs, 0 dementia diagnoses, 0 cognitive impairment indicators. The second thing I did was retrieve the estate planning file from the attorney who drafted her will. Recorded consultation notes, capacity checklist documentation, witness affidavits, everything compliant. Then I examined financial activity, every withdrawal, every transfer, every check, no irregular disbursements, no suspicious beneficiary changes, no liquidity drains. If I had isolated her, as my mother claimed, there would be transactional anomalies. There weren't. Instead, what I found was something else: receipts. See, abandonment leaves records too. My mother left when I was 14. No dramatic goodbye, no custody battle, just a quiet relocation to Arizona with a man she met at a trade show. My grandmother stepped in. School tuition, orthodontics, college application fees, first car down payment. There are bank transfers that map my upbringing. My mother sent exactly 4 birthday cards in 19 years. No financial support, no healthcare assistance, no visits during surgeries. But suddenly, after the funeral, she resurfaced with legal representation and an appetite for probate litigation. That's when the pattern emerged, and it was familiar. In elder exploitation cases, we look for what's called proximity activation. An estranged relative reappears shortly before or after death, claims emotional closeness, challenges estate documents. It's textbook. Except this time, the alleged victim wasn't an elderly widow. It was me, and the allegation wasn't theft of funds. It was theft of competency. Bradley Fenwick filed a petition claiming I had manipulated my grandmother during a period of cognitive decline. He attached a concern affidavit, signed by my mother, dated 2 weeks before my grandmother's death. Interesting, because my mother hadn't visited in 7 years. So I requested phone records. Guess what I found? 14 missed calls from an Arizona number in the month prior to the affidavit, all unanswered. 3 voicemail transcripts retrieved from my grandmother's landline, voicemails that shifted in tone. First, concerned daughter. Second, passive-aggressive guilt. Third, thinly veiled threat about making sure things are handled fairly. The affidavit wasn't based on observation. It was based on rejection, and rejection isn't evidence. But here's where it escalated. 2 days before the court hearing, I received a subpoena request. They wanted my medical records, 10 years' worth, mental health included. That's when I understood the strategy. Discredit the expert. If you can't prove undue influence, destabilize the witness. They weren't just contesting the will, they were constructing a narrative. Unstable daughter isolates elderly grandmother, manipulates estate, fabricates capacity. If they could introduce even a whisper of psychological instability into the record, the doubt alone could create leverage. I called the attorney who had drafted the will. He was furious, not defensive, offended. He offered to testify voluntarily regarding capacity documentation standards. Then I did something Bradley Fenwick did not anticipate. I ran a background audit on him. Newly licensed, 2 years in probate practice, no litigation experience beyond minor estate disputes, and one interesting detail: his firm had represented my mother's new husband in a failed business dissolution 3 years earlier. So this wasn't random representation, it was relational. That matters, because when legal strategy intersects with personal alliances, objectivity deteriorates. By the time we walked into Milwaukee County Courthouse that morning, I had assembled a binder. Not emotional letters, not character witnesses, documentation, medical certifications of cognitive competence, will execution compliance records, bank activity forensic analysis, phone transcript logs, affidavit timing discrepancies, and a professional CV that read like a demolition manual. My mother, however, walked in with anger. She didn't recognize the courtroom dynamic. She saw me as my 14-year-old daughter, not as a forensic financial investigator who had dismantled more complex schemes than hers before breakfast. So she stood. She screamed. She called me mentally incompetent. And the judge looked at her attorney like he had just detonated his own credibility. "Counsel, do you truly have no idea who this woman is?" The air shifted, because in that moment, the courtroom wasn't evaluating my sanity, it was evaluating his judgment. And in litigation, once the bench doubts your competence, you are already losing. But here's the part no one in that room knew yet. Not the judge, not Bradley, not even my mother. I hadn't just audited their claims, I had discovered something else, something buried in timing, something filed before the will contest. Something that suggested this wasn't a spontaneous grief reaction, it was premeditated, and the paper trail led somewhere none of them expected. But before I show you what I found, you need to understand who my mother really is. Because abandonment doesn't just leave emotional scars, it leaves patterns, and patterns leave evidence, and she had left a lot of both. When I was 14, my parents divorced. There were no shattered dishes, no police reports, no slammed doors, just signatures. Paperwork slid across a kitchen table that still had placemats from the night before. My father moved to Oregon within 2 months. A new job, a fresh start. That's what adults call it when they can't explain the fracture. My mother remarried 3 months later. Theodore Hollister. He owned 3 laundromats in Rhine County, coin-operated, fluorescent-lit, perpetually humming businesses that smelled like detergent and overheated motors. He also, apparently, owned my mother's future, because she didn't fight for custody, not even symbolically. No contested filings, no mediation drama, no teary insistence on weekends. She signed the agreement. Fast forward 19 years. My grandmother dies, my mother resurfaces, and suddenly I am mentally unstable? No, that accusation wasn't random. It was engineered, because in probate litigation, capacity is leverage. If the court declares the primary beneficiary incompetent, control shifts. If control shifts, asset distribution can be delayed. If distribution is delayed, settlements happen. And if settlements happen, percentages move. Guess who filed for emergency conservatorship? Daisy Hollister, my mother, the woman who hadn't visited her own mother in 15 years. The petition claimed serious concerns regarding Nancy Berglund's mental fitness to execute fiduciary responsibilities. It cited history of adolescent psychological instability, ongoing therapy suggesting unresolved trauma, questionable emotional regulation. Attached to the filing, my therapy records from when I was 14, after she left. A school counselor's note describing low self-worth and abandonment distress. That line was highlighted. Presented not as situational grief, but as chronic impairment. 14-year-old pain repackaged as lifelong mental illness. It was almost impressive in its manipulation. Almost. My firm received notice within days. In forensic accounting and fraud examination, credibility is non-negotiable. An active mental competency dispute? That's exposure. I was placed under administrative review. No new cases, no courtroom testimony, no external consulting. 7 years of reputation paused. Not revoked, paused, which is worse because a pause implies pending validation. Clients called, gently, curiously, concerned about scheduling continuity. They weren't questioning me directly, they were questioning risk, and risk is contagious. That's when I stopped finding the situation ironic, because this wasn't emotional sabotage, it was tactical destabilization. The sequence was too precise. Grandmother dies, will filed, contest initiated, conservatorship petition attached, mental records introduced, professional credibility frozen. That's choreography, and choreography requires motive. So I did what I always do. I followed the money. The first thing I examined wasn't my grandmother's accounts. It was Theodore Hollister's businesses. 3 laundromats in Rhine County. Public records showed declining revenue over the past 5 years. Commercial property tax liens on one location. A small business loan taken 18 months ago. Refinanced twice. Interesting. Then I looked at property ownership records tied to my mother. 2 vehicles financed. Primary residence mortgaged at near appraisal value. No significant personal assets. No investment accounts of substance. Then came the detail that shifted this from suspicion to structure. 3 months before my grandmother died, my mother and Theodore filed paperwork to create a holding company, Hollister Asset Management, LLC. Registered purpose? Real estate acquisition and estate administration services. That's a curious business category for people who own laundromats. Even more curious, the LLC was registered in Wisconsin, not Arizona where they lived. Why register in Wisconsin unless you anticipate managing Wisconsin assets? I requested corporate filings. The operating agreement allowed for temporary fiduciary oversight of inherited or disputed estates. Temporary fiduciary oversight. That language is surgical, because if a court declares the primary beneficiary incompetent, the estate requires a fiduciary. And if a newly formed LLC exists with that language pre-written, the appointment becomes convenient. Now, we're not talking about grief, we're talking about infrastructure. The timeline sharpened. LLC formed 3 months prior to death. My grandmother's health declines. My mother begins calling repeatedly. Affidavit alleging cognitive concerns drafted. Will contest filed. Emergency conservatorship petition attached. This wasn't reactive, it was anticipatory. But anticipation requires information, which raised the question, how did she know to prepare? My grandmother didn't disclose the will contents to anyone except me and her estate attorney. She wasn't careless, she was procedural. So I pulled phone records again, this time broader, not just the final month, the final 6 months. There were calls between my mother and a former neighbor of my grandmother's, a woman named Patricia Klein. Patricia had recently begun helping with grocery runs after my grandmother's heart failure diagnosis. Patricia had also been present the day my grandmother met with her estate attorney for a routine document review. Interesting. I ran Patricia's name through. Once, on the second withdrawal, she leaned forward and spoke before my grandmother did. The teller redirected eye contact to my grandmother. Protocol. Good teller. But the physical proximity was instructional. Undue influence often manifests in posture before paperwork. Still, influence isn't fraud. Not yet. So I went to the bank's safe deposit box. My grandmother rarely used it. Jewelry. Her original marriage certificate. A small velvet pouch of coins from 1964. And a brown leather journal. I recognized it immediately. It used to sit in her nightstand. She called it her quiet record. Her handwriting was precise, teacher-perfect penmanship. Every entry dated, every page numbered. She documented every visit from Daisy, every conversation, every temporary loan request. She recorded emotional tone, body language, exact phrasing. It wasn't paranoid, it was archival. Then I found the entry that made my hands shake. Signed power of attorney today. Foggy. Didn't feel right. Dated May 14th, 2024. 2 weeks later, think I was tricked, too embarrassed to tell Nancy. There it was. Cognition. Self-awareness. Shame. If she had truly been cognitively impaired, she wouldn't have documented doubt. She would have normalized the event. Instead, she recorded suspicion. That entry alone reframed everything. Because now we weren't just examining withdrawals, we were examining authorization. I requested a certified copy of the power of attorney filed with the county. Durable financial power. Grantor, Dorothy Berglund. Agent, Daisy Hollister. Date, May 14, 2024. Notarized. Witnessed. Legally formatted. At first glance, it looked compliant, until I examined the notary stamp. The seal belonged to a retired notary. Commission expired in 2019. The document was dated 2024. That's not administrative error. That's forgery. Forgery is a felony in Wisconsin. But fraud isn't proven by one defective document. It's proven by pattern and intent. So I expanded the audit. If Daisy had executed a forged POA to access my grandmother's funds, there would be transactional behavior consistent with agent authority. And there was. 3 of the 7 withdrawals were executed using agent signature line authorization, not my grandmother's signature, Daisy's. The bank had accepted them under the power of attorney because the document appeared valid. So I compared signature samples. My grandmother's authentic signature over the past 10 years, Daisy's signature from property records, and the signatures on the POA. The grantor signature was close, but not consistent. The loop on the D in Dorothy was slightly compressed, pen pressure heavier on downstroke. And here's the detail only forensic document examiners obsess over. My grandmother always crossed her T in Berglund with a slight upward angle. The POA signature crossed it flat. Micro discrepancy, macro implication. Now the question shifted. Was this a single opportunistic forgery, or was this behavior historical? So I looked at Theodore, his financial past, his first wife's estate. Public probate records revealed minimal assets at distribution, but I located bank statements attached to an old civil dispute. 3 cash withdrawals in the final 6 weeks before her death. Total, $22,000. No charges filed, but timing mirrored the current pattern. Then, his mother's estate, small property in Rain County. 6 months before death, $31,000 in cash withdrawals. Again, no criminal filing, but again, clustering. And again, proximity to Theodore. Different victims, same structure. High-value cash extractions shortly before death, minimal documentation, family silence. That's not desperation, that's rehearsal. They weren't improvising with my grandmother. They were executing a familiar playbook. Step 1, reestablish proximity. Step 2, assert concern over capacity. Step 3, introduce legal instrument. Step 4, extract liquid funds. Step 5, prepare for estate leverage. And now they had escalated, because this time, instead of stopping at withdrawal, they attempted full estate control via conservatorship. Overconfidence breeds sloppiness. Sloppiness leaves evidence. Which brings us to the LLC. Hollister Asset Management, LLC. I obtained its internal filings through a subpoena request tied to the probate dispute. The operating agreement contained a clause authorizing temporary management of estates under legal contest, where fiduciary control is deemed compromised. The clause was drafted before my grandmother's death, not after, meaning they anticipated contest, which means they anticipated resistance, and anticipation implies planning. Now here's where strategic restraint matters. When you uncover this level of exposure, instinct says file criminal complaint immediately. But premature exposure can allow defendants to consolidate assets, destroy records, reframe narrative. So I did something that confused my own attorney. I played small. In court filings, I focused narrowly. I challenged only the validity of the power of attorney, not the broader estate pattern, not the prior estates, not the LLC infrastructure, just the notary discrepancy. Why? Because once the POA was invalidated, every agent-authorized withdrawal became unauthorized by definition, and unauthorized withdrawals under a forged instrument constitute theft. Let them argue dementia. Let them argue emotional instability. They couldn't argue a retired notary's stamp. When the judge reviewed the commission expiration date, she didn't react dramatically. She leaned back, folded her hands, and asked opposing counsel if he had independently verified the document. He had not. Bradley Fenwick's confidence fractured in real time. But I wasn't done, because while the courtroom focused on document validity, I was preparing the criminal referral package. Bank surveillance stills, journal excerpts, signature comparison matrix, LLC formation timeline, prior estate cash clustering analysis. Fraud cases collapse without narrative clarity, so I structured it as a timeline, not an accusation. Date. Action. Financial movement. Corroborating evidence. Let investigators draw the conclusion. That's how you avoid appearing vindictive. But here's the detail that made the entire case irreversible. One of the $12,000 withdrawals was deposited, in cash, into Hollister Asset Management's newly opened business account 2 days later, structured as capital contribution. That's laundering, and laundering converts suspicion into felony stacking. At that point, the case was no longer about inheritance, it was about criminal enterprise. But externally, I stayed quiet. I allowed Daisy to continue portraying herself as the wronged daughter. I allowed Theodore to sit in court with composed indignation. I allowed Bradley to believe this was a simple probate fight. Because when people believe they are winning, they expose more. And they did. During a supplemental filing, Bradley submitted an affidavit claiming Daisy had been financially supporting her mother for months prior to death. Attached were photocopies of checks. The handwriting on the memo lines? Not Daisy's. Not my grandmother's. Patricia Klein's. The neighbor. The former notary. And now likely co-conspirator. Which meant the structure was bigger than one forged stamp. It was coordinated. 3 actors, defined roles, financial motive, pattern history. At that point, my attorney finally understood why I hadn't rushed. Because fraud is not about the first irregularity, it's about the ecosystem. And ecosystems reveal themselves when left undisturbed. But there was still one vulnerability. If the court ruled on the will before criminal charges were filed, asset freeze authority could weaken, so timing became critical, which meant I needed one final piece of leverage, something procedural, something they wouldn't anticipate, and I found it buried in county property records, a lien, filed quietly, against one of Theodore's laundromats by the IRS 3 months before the LLC was formed. Now, motive had urgency. Debt pressure accelerates fraud behavior. They weren't just opportunistic, they were cornered, and cornered actors escalate, which meant this wasn't over. Not in probate, not in criminal court, and not inside that courtroom where my mother had stood up and screamed. Because once the money trail speaks, it doesn't whisper, and I was about to let it testify. I hired Caroline Jankowski. If you've worked long enough in financial litigation, you learn the difference between loud attorneys and lethal ones. Caroline was lethal. Mid-40s, unshakable posture, voice calibrated just above conversational level. No theatrical outrage, no dramatic objections, just precision. She had spent 15 years in white-collar defense before transitioning into complex civil litigation. She understood fraud architecture. She understood prosecutorial psychology. And more importantly, she understood timing. When I laid out everything I had uncovered, the forged power of attorney, the clustered withdrawals, the LLC formation timeline, Theodore's historical estate patterns, she didn't react emotionally. She didn't even smile. She just asked one question. Do you want vindication or conviction? I said, both. She nodded. Then we don't show them everything yet. That's when the strategy shifted from investigation to performance. Because court isn't just about truth, it's about sequencing. We filed a minimal response to the will contest and conservatorship petition. No aggressive language, no accusations of fraud, no exhibits attached. Just a procedural denial and a request for evidentiary hearing. Bradley's Fenwick responded with confidence. He filed a supplemental memorandum outlining my documented psychological instability. He attached excerpts from my adolescent therapy notes. He framed my career as mid-level accounting employment. Mid-level. I didn't correct it. At deposition, I downplayed everything. Caroline instructed me beforehand. Answer exactly what is asked, nothing more, no expansion. So when Bradley asked about my education, bachelor's degree in accounting. When he asked about employment, I work in financial investigations. When he asked about therapy, yes, I attended counseling at 14. He tried to bait me. You've experienced emotional distress in the past, correct? Yes. You have unresolved trauma related to abandonment. I've processed childhood events in therapy. He wanted admission language. He wanted instability language. I gave him clinical neutrality. What I did not mention, certified fraud examiner credential, 38 court testimonies, 31 convictions, 11 appearances before Judge Kowalczyk. I didn't mention that I had dismantled elder exploitation rings larger than this one. I let him believe he was deposing a defensive daughter. I let Daisy believe I was fragile, because arrogance makes people careless, and careless people escalate in public. On March 14th, they walked into court relaxed. You can tell when opposing counsel believes they've won. Their posture softens. Their small talk increases. Bradley shook hands with another attorney in the hallway. Daisy wore a cream blazer, and my grandmother's pearl earrings. That detail matters, because entitlement always shows itself. Those earrings were never gifted to her. They were stored in the safe deposit box. Which meant she had accessed the box using the forged power of attorney before we froze accounts. It was subtle, but it was symbolic. She believed possession was victory. Court convened at 9 a.m. Judge Kowalczyk entered with the same measured presence she always carried. No wasted motion, no wasted words. Bradley began. He outlined the narrative. Estranged daughter manipulates elderly grandmother. History of emotional instability. Isolation during declining health. Questionable financial stewardship. He referenced my therapy records. He emphasized documented concerns. Then Daisy stood. Unprompted. She wasn't scheduled to speak. She just stood. And she screamed, not theatrically, not performatively, emotionally unregulated. She is mentally sick. Her voice cracked against the courtroom walls. She has always been unstable. She manipulated my mother. She isolated her. She is dangerous. Dangerous. That word lingered. I didn't move. Caroline didn't move. Judge Kowalczyk let the silence settle. Then she looked at Bradley and asked, "Counsel, do you truly have no idea who this woman is?" It wasn't rhetorical. It was surgical. Bradley hesitated, and in that hesitation, courtroom hierarchy shifted, because judges do not ask that question unless they know something you don't. Caroline stood, slowly, Your Honor, she began evenly, with the court's permission, we would like to submit additional exhibits. Bradley objected reflexively. Untimely disclosure. Caroline didn't raise her voice. These exhibits directly rebut the allegation of incompetency and demonstrate material fraud in the petitioner's filings. Fraud. First time the word entered the record. Judge Kowalczyk nodded. Proceed. That's when we opened the evidence file. Exhibit A. 2 years of bank statements. Highlighted withdrawals. 7 clustered cash movements totaling $47,850. Exhibit B. Visit log correlation chart. Green ink calendar entries aligned with withdrawal dates. Exhibit C. Surveillance stills from 3 bank visits. Daisy positioned directly behind my grandmother. Exhibit D. Brown leather journal excerpts. Handwritten entries documenting discomfort regarding power of attorney. Foggy. Didn't feel right. You could hear paper shifting in the courtroom. Exhibit E. Certified copy of the power of attorney. Enlarged image of notary seal. Commission expiration date 2019. Document execution date 2024. Caroline paused, then submitted the affidavit from the retired notary. She had not notarized any document in 2024. Forgery proof. Exhibit F. Signature comparison analysis. Visual overlays of authentic signature versus POA signature. Micro discrepancies highlighted. Exhibit G. Hollister Asset Management LLC operating agreement. Formation date 3 months prior to death. Clause authorizing fiduciary oversight of contested estates. Exhibit H. Deposit record showing $12,000 cash placed into the LLC account 2 days after withdrawal, structured as capital contribution. Then came Exhibit I. Comparative estate pattern analysis. Caroline summarized it without theatrics. In 2 prior estates associated with Mr. Theodore Hollister, similar clustered cash withdrawals occurred within 6 weeks of decedent death. No charges filed. Pattern consistent. The courtroom temperature changed. I watched Bradley lean toward Daisy, whisper urgently. I watched her confidence evaporate in real time. Her shoulders tightened, her eyes moved for the first time not toward the judge, but toward me. And in that moment, she really looked, not at her daughter, at her mistake. Recognition is visible. It's the collapse of narrative. She understood. This was not an emotional dispute. It was exposure. Bradley stood abruptly. Your Honor, we would like to withdraw the petition. Too late. Judge Kowalczyk didn't blink. Denied. Her voice carried finality. This court has reviewed sufficient preliminary evidence suggesting potential criminal conduct. The matter is referred to the district attorney's office for investigation. She paused. And given the interstate financial implications, referral to federal authorities is also appropriate. The FBI. The word wasn't dramatic. It was administrative. Administrative referrals end arguments. Petition denied with prejudice. With prejudice means you don't get to try again. Daisy's composure fractured. She attempted to speak again. Judge Kowalczyk stopped her. This court will not tolerate exploitation of vulnerable persons or misuse of mental health records as strategic leverage. That line entered the transcript. Bradley gathered his papers too quickly. Papers spill when hands shake. Caroline remained still. Because the performance wasn't emotional, it was structured. After adjournment, as we stepped into the hallway, reporters weren't waiting. This wasn't that kind of case. White-collar exposure rarely draws cameras. It draws subpoenas, and subpoenas take time. Daisy passed me on the way out. She didn't speak. She didn't apologize. She didn't justify. She just avoided eye contact. Because once evidence replaces narrative, there is nothing left to scream. But this story wasn't over. Criminal investigations move slowly. Asset freezes take weeks, forensic audits expand, grand jury reviews take months, and reputational repair takes even longer. My firm reinstated me within 2 weeks. Administrative review closed. No findings. But credibility doesn't snap back instantly. It rebuilds incrementally. And consequences? Consequences take time. Search warrants would be executed quietly, financial records subpoenaed, prior estates re-examined, Patricia Cline interviewed, the retired notary questioned, the LLC scrutinized, the IRS lien contextualized. Because once a fraud ecosystem is exposed, investigators don't stop at one node, they map the network. Time was finally on my side. Not because I had won emotionally, but because the architecture had shifted. For 19 years, my mother believed silence was power. She left. She disappeared. She reappeared when money was available. She weaponized my adolescence. She underestimated my profession. She screamed in court. But performance without preparation collapses under documentation. And that courtroom, it wasn't the climax, it was the trigger. Because when the woman the judge recognized finally spoke through evidence, the system listened. And this time, it wasn't just about inheritance, it was about indictment. The referral didn't sit in a file. It moved, quietly, efficiently, methodically. When fraud cases transition from civil exposure to federal review, the energy changes. It becomes less emotional, more mechanical. Timelines tighten, subpoenas multiply, phone calls become formal interviews. The FBI moved quickly. Wire fraud, mail fraud, financial exploitation of an elderly person, forgery, interstate financial structuring. The charges weren't dramatic in tone, they were precise. Each count mapped to a transaction, a document, a deposit, a signature. On April 2nd at 6:12 a.m., Daisy Hollister and Theodore Hollister were arrested. Not in a cinematic raid, in controlled, procedural fashion. Agents knocked, presented warrants, explained charges. Neighbors watched from behind blinds. There's something sobering about seeing a life built on performance collapse under documentation. 5 years for her, 6.5 for him. Federal sentencing guidelines don't respond to emotion. They respond to monetary thresholds, intent, pattern history, and obstruction factors. The forged power of attorney elevated the severity. The structured cash deposit into the LLC compounded it. The evidence of prior estate patterns influenced sentencing. Restitution ordered $47,850 plus accrued interest. But restitution was only one layer. The laundromats were seized under asset forfeiture statutes. Their primary residence was liquidated. The IRS lien surfaced during forfeiture review. Country club membership terminated. Everything built on leveraged access to vulnerable assets collapsed. Fraud ecosystems look stable until liquidity is examined. Then they disintegrate. The criminal process took months to finalize, but the outcome was inevitable once the financial architecture was mapped. No plea theatrics, no dramatic courtroom apologies, just sentencing. And then silence again. But this time, the silence was clean. My grandmother's estate settled in July. No further contest, no appellate filings, no conditional agreements. Final distribution executed under court supervision. I kept the house. 43 years of continuity in Eau Claire. The hardwood floors still dip near the hallway. The kitchen still smells faintly like coffee on Sunday mornings. I kept the journal, every page intact, every entry dated. Documentation of doubt, documentation of strength, documentation of clarity. And I framed one page, the entry dated 2 months before she died. It reads, "Nancy sees things clearly." That sentence matters more than the conviction, because clarity was always the inheritance. Not the house, not the savings, not the insurance policy. Clarity, the ability to observe without reacting, the discipline to document before confronting, the patience to let arrogance expose itself. Cameron proposed in October. He had stood beside me through administrative review, deposition stress, reputational uncertainty. He never once asked if the allegations might be true. He asked instead, "What's the next step?" That's partnership. I said yes, not because the storm was over, but because I knew I could navigate storms. My firm reinstated me fully after the criminal referral was confirmed. Administrative review closed with written acknowledgement, no evidence of misconduct, professional standing restored. But reinstatement is not the same as restoration. Restoration is earned, so I returned to work deliberately. My first case back involved an 84-year-old woman whose nephew had diverted $89,000 through online banking manipulation and coercive signature control. The pattern felt familiar: isolation, access, unauthorized transfers masked as loans. We reconstructed the digital footprint, recovered the funds, filed charges. When the woman thanked me, she said, "I didn't want my family torn apart." I understood that. Fraud rarely begins as hatred. It begins as entitlement, and entitlement justifies harm quietly. Because this was never about revenge. If I had wanted revenge, I would have exposed everything at once, filed criminal complaints immediately, sought media coverage, public humiliation. But revenge is reactive. Balance is procedural. Balance is allowing systems to function once evidence is positioned correctly. My mother thought silence meant weakness. She confused non-reaction with incapacity. She forgot who raised me, a retired school teacher who reconciled her checkbook every Sunday without fail, a woman who believed documentation was protection, a woman who taught me that money tells the truth if you know how to listen. When I walk through the house now, I notice small details I didn't before. The envelope drawer in the kitchen, still organized by year. Utility bills stacked chronologically, donation receipts clipped together. I haven't changed that system. I added to it. Court transcripts from March 14th are stored in a labeled binder. FBI correspondence filed behind estate documents. Restitution confirmation letter clipped to the bank reconciliation sheet. Closure, in my world, is archived. I visit her grave on Sundays sometimes. Not every week, but often enough. I tell her what's been resolved. I tell her the house is intact. I tell her the journal is safe. I don't tell her about Daisy, not because I'm protecting her memory, but because it doesn't matter anymore. Consequences were delivered through system, not emotion, and that's the only kind that sustains. There's a misconception that justice feels triumphant. It doesn't. It feels quiet, like a ledger balanced at the end of a long reconciliation. No surplus, no deficit, just equilibrium. The pearls? They were returned, retrieved from evidence storage after seizure inventory. I keep them in the same velvet pouch from the safe deposit box. I don't wear them often. There aren't decoration. They're reminder of proximity, of patience, of the moment entitlement revealed itself in a courtroom. If you followed this entire story, you understand something critical now. Fraud is rarely explosive. It's incremental. It relies on distraction. It depends on emotional noise. Documentation defeats manipulation because documentation is unemotional. It does not scream. It does not accuse. It records. Patience outlasts cruelty because cruelty burns fast. Paper trails burn slowly. And truth? Truth does not need to scream. It needs to be positioned. There's a reason elder financial exploitation cases often go unprosecuted. Shame, family dynamics, fear of public exposure. But patterns do not disappear because we avoid them. They repeat until someone interrupts them with evidence. That's what my grandmother did, even when she felt embarrassed, even when she felt foggy. She documented. That documentation became the fulcrum. The system tilted because she wrote the truth down. If this story resonates with you, not as drama but as architecture, then you understand the value beneath it. Quiet strength is not passive. It is strategic, and strategy wins over spectacle every time. If you believe justice should always leave a paper trail, hold on to that belief. If you work in finance, law, compliance, caregiving, remember this: patterns speak before people do. Listen early, document consistently, and never underestimate the power of playing small until it's time to open the file. There are more stories like this, stories about quiet investigations, about underestimated women, about systems that function when evidence is aligned correctly. If you're ready for another one where patience reshapes outcome again, it's waiting. I'll see you there.